Sewing and craft giants JOANN and Design Group America's return to bankruptcy court, and there is a lot to talk about. Welcome to Sewing Report Live. I'm Jen. I do news and commentary within the sewing and craft world, and we have quite a bit to break down from two court hearings, same day, two different companies. Just a quick disclaimer before we get started. I am not an attorney, and this is not official legal analysis. Also, these videos are unscripted and minimally edited, so keep that in mind. We've been doing a lot of coverage on both of these bankruptcy cases, and they are still ongoing. I know JOANN's stores are out of business, but there's still a lot to wrap up, including this separate lawsuit out of Ohio that is accusing former JOANN executives of fraudulent misrepresentation and negligence. So we're going to go over what happened in court. So we're going to do JOANN's first, and then I will get to Design Group America's. Their hearing was much shorter, and they did have some notable news that I do want to get to. But the JOANN's hearing was a lot bigger, and there was more going on. That hearing was over 2 hours long. That one took place in a Delaware bankruptcy court, and it's being handled by Judge Craig Goldblatt. I know we've been hearing a lot from him, and I feel like I know him personally by now. I know we've watched so many of these hearings I've been sitting into, so I sat in on both of these court hearings, so you don't have to. So what happened at today's hearing with JOANN's? There was basically two big issues, although one was like a lot of smaller issues rolled into one. First, they did go over the Ohio lawsuit, and then there were also a lot of there was a lot of other smaller issues, but they all had to do with assigning leases of former JOANN stores. JOANN had tried to assign a lot of their former leases. They did not own a lot of the real estate. They had landlords in a lot of these shopping centers, and they found other retailers to come take over their leases, and some of the landlords had issues with them doing that. Okay, but first we're really going to talk more about the Ohio lawsuit. So we've been covering this pretty extensively, but several of the former JOANN vendors are suing some of the former company executives, and this includes the Woobles company, Low Tech Toys, and several others. If you want to see some of the previous coverage, I'm not going to go down that whole rabbit hole today, but we are going to talk about the latest. So here's the deal. This lawsuit was filed in an Ohio state court, and it's on behalf of several of the JOANN vendors who are also creditors in the bankruptcy case out of Delaware. Now, these are two separate things, but the JOANN executives are trying to they're trying to do a few different legal maneuvers, but they really don't want to be held liable on an individual level for obvious reasons, and they're trying to get this rolled into the bankruptcy case, or at least kind of dropped altogether, from what I understand. So two of the people who were speaking at the hearing were attorneys for both sides. All right, so I'm going to bring up these attorneys here. So attorney Gordon Novod he's with a law firm called Grant and Eisenhofer. He specializes in bankruptcy and distressed litigation practice, so seems right up his alley. And I gotta say, this guy was pretty impressive. I found him really interesting to listen to and hear his legal arguments. So he is representing the plaintiffs in the Ohio lawsuit against the JOANN executives. And it was filed in a state court, so kind of more of a local court. But then I believe it's now sitting in a federal district court in Ohio. And there have been a few different filings from both sides. And we're going to talk about this because this is kind of interesting. And the attorney representing the defendants in this case, or the JOANN executives, is Bill Arnaut from Kirkland and Ellis. Now, Kirkland and Ellis is also representing JOANN's in the bankruptcy case. So I believe, I'm going to guess the JOANN executives probably also have other lawyers, but it kind of seemed to me like Bill is representing the defendants in the Ohio lawsuit, or the former JOANN executives, just in terms of fighting this in the Delaware bankruptcy court. And I'm going to guess, because I didn't see him or Kirkland and Ellis listed on the Ohio lawsuit representing the defendants, but it seems like he's just representing the defendants in Delaware. So they're fighting this on two different fronts here. So this is a little bit complicated to break down, but I'm gonna try to explain this the best I can from a non-attorney. But from what it looks like, the lawyer Gordon Novod for the plaintiffs in the Ohio case, now those are, let me pull this up real quick. These are the ex-vendors, and they're saying that they were misled by JOANN representatives and into thinking that JOANN's financial position was a lot better than it was in between the first and second bankruptcies. And they are using state laws. So these companies are located in a few different states, but the JOANN headquarters was in Hudson, Ohio. So that's why they filed this lawsuit in this state court out of Ohio. I believe they said Akron. So the plaintiffs in this case are Advantis Corp., Fairfield Processing Corp., Gwen Studios LLC, Low Tech Toy Club LLC, that is the Woobles Crochet Kits, Ormo, Ithalet, Erekat AS, and Springs Creatives Group LLC. The defendants are, look at this, the former JOANN executives and officers, Michael Prendergast, Jeffrey Dwyer, Robert Will, who's now, coincidentally, the CEO of SVP Worldwide, Christopher DiTullio, Heather Holliday, Michael Kennedy, and Melissa Bowers. So it says it's right now in the U.S. District Court for the Northern District of Ohio. And this was pretty fascinating because the lawyer for the plaintiffs in this case is saying this is actually a separate lawsuit, and it should be seen as a separate lawsuit because we are using a state law. We're using these state laws, and it's not part of the bankruptcy. So he even said, we're accusing them of, I believe it was like common. I'm going to play some clips for you because this was pretty interesting to see these attorneys go back and forth. There actually was some pretty hot legal action in this hearing, which was kind of exciting because a lot of the other hearings have been pretty dry, dull, not super interesting, just from a normie perspective. But Bill Arnott, who's representing the defendants or the debtors for JOANN, he's saying, hey, this lawsuit is really a derivative of the bankruptcy case, really shouldn't be a separate case at all. So that, again, of course, they're going to be fighting for their own clients' best interests. So he works for Kirkland and Ellis, and Bill was basically saying, hey, this is really a derivative case, and we should be protected under so he filed a preliminary injunction in the Delaware bankruptcy court case, trying to basically get his clients or the ex-JOANN executives protection under the bankruptcy law from this other lawsuit out of Ohio. But Gordon, the attorney for the plaintiffs, is like, no, this is not a derivative case. We're going under state law, state laws here, and they're going at it from the perspective of this should not be considered part of the bankruptcy case. So really the dispute during this court hearing was, all right, I got some notes here, but basically it was that the Kirkland and Ellis guy, Bill Arnott, had filed a preliminary injunction, and that would stop certain actions or proceedings while a bankruptcy case is being resolved. But the lawyer for the Ohio they were calling them Ohio plaintiffs, was saying, hey, they're really kind of misfiling this, and they're trying to use a preliminary injunction like a, what did they say? Like a plea to the motions or something like that. Or a, it was like a common law pleading, something along those lines. But they were basically saying that they were trying to use what's supposed to be a not permanent thing and turn it into permanent protection for the Ohio defendants, when that really shouldn't have been the case, and that they needed to file it as something different. So I thought that was pretty interesting. I'm going to play some clips of the attorneys and the judge going back and forth because I thought it was pretty fascinating. So take a listen. This is kind of long, but I just found it pretty interesting.
There's just a threshold issue between the parties as to how to proceed. And it really comes down to, what is the hearing on our motion to enforce the sale order entail from an evidentiary perspective, if any? And then connected to that is whether there's any discovery that's necessary before we move to oral argument.
Your theory in support of the motion to enforce the injunction or the adversary or what have you, I take it, is that the claims that the individual claimants are pursuing are essentially estate causes of action under Emerald or what have you, and therefore, because the estate sold those claims to the buyer, the individuals don't have them and can't pursue them. Am I right about what's at issue?
That's exactly right, Your Honor. That's what issue, whether these are direct or derivative claims. And our view is that they're derivative claims, and so they were sold under the sale order. And as it pertains to the status conference and discovery, our view is that that's solely a legal question, such that no evidence is required. And based on looking at all the cases, the legal framework here, we think that really all that's required is just an examination of the complaint, and more specifically, what is the theory of liability and the nature of the claims. And it's not meant to be some analysis into the merits of the claims. Right. And really, sorry, Your Honor, I liken this to a motion to dismiss type argument, where you look at the complaint, accept essentially as true, what are the allegations in the complaint, what are the claims that have been asserted. And I think if I'm right that that's the correct legal framework, then we don't need discovery to test the veracity of the allegations, because there are allegations that are in the complaint that the court needs to examine to make that determination. And I think consistent with that theory of the world and how this should proceed, as we've told counsel for the Ohio plaintiffs, we're not going to call any witnesses. We're not going to seek to introduce additional evidence, because I just don't think that's the correct approach. And B, as a practical matter, we start to get into how does that discovery overlap with the underlying action? And I just don't know how you start to police a deposition in that scenario. And of course, we have the practical overlay of a limited wind down budget. So spending the next however many months doing depositions, responding to 40 document requests, 28 interrogatories, it doesn't seem like the best approach here, when I do think that this is just a legal question, particularly because initially we had filed a motion for an injunction, and the concern was that the Ohio state court action would get out in front of this threshold question. Now that is subject to remand briefing, transfer briefing, there's no longer that concern. And so it's really been narrowed to this legal question of direct versus derivative, for which, again, we don't think we need any evidence. We don't think that's the right way to analyze it. And so we think, given the state of play and the legal framework here, proceeding to oral argument on those issues is the best course of action, both because it's the right process, but also practically.
Just initially, my clients filed actions in a single complaint in the Ohio Court of Common Claims in Akron, Ohio, which is the same court in which the debtor is situated. The claims themselves are brought against a number of former employees of JOANN's, as well as 2 former officers of JOANN's. The claims at issue in that case, as pled, are they are common law fraud, that's one, and negligent misrepresentation. Now, the common law fraud claims are pled in the complaint with the necessary elements having been pled, which are an omission or misstatement, reliance, scienter, as well as damages. These are not, and I'll get to it directly, but these are not derivative claims in any way. These are direct claims under state law. They exist and have existed forever for those purposes, and they're not claims that the debtor's estate could ever step into the shoes of the individual creditor and prove reliance. The debtors here have candidly asked the court to throw procedure on its head. In a motion to dismiss, that's one way of treating it, but this feels a lot more to me like a motion for summary judgment by the debtor, where the debtor is saying as a matter of law, there are no disputed facts and they have an entitlement to some judgment here, as opposed to a motion to dismiss.
Look, if taking the allegations here, I mean, maybe it's the motion to enforce the injunction is effectively judgment on the pleadings. If we can, I take it you don't have any issue with, on the motion the debtors have brought, my accepting the fact of the allegations in the complaint as this is what you're alleging, right?
I do not. However, Your Honor, I do believe that the debtor's motion and their reply brief make factual assertions which go to the very merits of the claim and whether that's going to be a direct or derivative claim. And for example, if you have before you our joint statement, we listed 7 different instances of factual statements in the debtor's reply brief as well as the debtor's brief, which make factual allegations that go to the application of a moral and that we've sought discovery on. And so in my view, the debtor can't make those judgments and those assertions, such as every creditor has a similar claim and injury as the ones being asserted by the Ohio plaintiffs. That's in paragraph 1 of their reply brief. Yeah, in their reply brief, the debtor said, we're no longer seeking a preliminary injunction. Rather, we're seeking enforcement solely of the sale order. That's the debtors, what they said in their papers in this very submission.
So they want essentially a permanent injunction, not a preliminary injunction.
That's right.
Okay.
So, and the debtor's explanation was we sought that at a time and we didn't want that getting ahead of plan confirmation. But now, since the plan has gone effective, in essence, what the debtor is looking for, and this is really the wind down debtor at this point, not the debtor anymore, but the wind down debtor is really seeking a permanent injunction and a finding from Your Honor that the filing of our complaint in Ohio State Court violated the terms of the automatic stay, which was then enforced as applicable to the debtor's estates, and that the claims themselves were sold to the purchaser.
But Mr. No, what about in the first instance, okay, you want to move for judgment on the pleadings, give me that piece of paper, let them respond to it, and then let's proceed that way.
Your Honor, that's totally fine. We had actually talked about that just because, as I had mentioned, events had overtaken the initial relief that we were seeking. And so really, this is a motion to enforce the sale order, which I think we can style as a motion for judgment on the pleadings. And again, so we are happy to cabin this to the complaint. I think that is the correct legal analysis here and the correct framework, and we don't need to go outside, and we shouldn't be going outside the complaint. And in fact, I don't want to get too far ahead of ourselves, but if you look at the allegations of the complaint, there's a number of generalized allegations about the representations that were made to the company's vendor base. So we tethered what was in our reply brief and what's in our pleadings to what's actually in the complaint. But that's not a today issue. But I say all that, so we're happy to refile something that is narrowed down to what we believe are actually what remains at issue, and then proceed to well, I guess we'll see how we proceed. But I think in that world, we have the courage of our convictions because we think this is how it works. And what we're hearing is, well, you need evidence, and if I don't put evidence on, then that's on me.
We do have discovery disputes, but in light of the fact that the debtor is proceeding, or at least proposing to proceed with the filing of a new motion to set this up procedurally, I would propose just to hold those disputes in abeyance until we actually know whether Your Honor will find that discovery is appropriate or whether this can be dealt with at the beginning. So we're not going to make sure in our statement that we filed with the court the week before last, we said that there were disputes that we would bring to the court when those are ripe. I don't think you'll be seeing those anytime soon until Your Honor decides this other motion.
And I found the correct term. The attorney for the Ohio plaintiffs is basically saying you need to file a new motion for judgment on the pleadings. But there was some back and forth because, as you could hear, they were like, hey, how do you even know this would meet meet all the criteria for this injunction? Because there is some dispute on the facts, and the Ohio plaintiff's attorney really wanted to get to discovery so that they could, really hammer out the dispute on the facts of this case. So for now, that's kind of on hold, but there's going to be some more filings. This is probably going to go on for a while, so I don't think this is going to be resolved. I don't know if this is going to be resolved anytime soon, but there's going to be some more hearings, and they're going to try to get this figured out. But I think it's pretty interesting because the attorney for the Ohio defendants, or the JOANN executives, they were trying a couple different legal maneuvers. One, get the lawsuit stopped under this injunction, basically saying, hey, this should really be part of the bankruptcy case, and any of the claims would have been sold to whoever purchased all of the JOANN assets, which was the Great American Group, I guess. And then they were also simultaneously trying to get get a change of venue, so they already got it moved to the federal court in Ohio or the district court, but then they were simultaneously either trying to get the stay, but also trying to get the venue changed to the Delaware bankruptcy court. Again, I'm not an attorney, but that's, from what I can tell, that seems to be what they're doing. But I found this Gordon Novod guy to be pretty interesting, so I'm going to be keeping an eye on him. And I also noticed there was some interesting, I'm gonna show you this, because there was some pretty interesting back and forth on LinkedIn about the case. I saw Gordon had posted some stuff, so I'm gonna show you this. So I was trying to look up Gordon Novod to see what the deal was with this lawyer, because I was like, oh, this guy's pretty interesting. And so there was somebody had posted about the lawsuit on LinkedIn. So this guy, Joseph Sarachek, he is a restructuring advisor, and he posted about this on LinkedIn. Vendors take action against JOANN Fabrics officers and restructuring professionals. A group of JOANN Fabrics creditors are fighting to be paid for their goods for misrepresentations made by current and former officers and employees of JOANN Fabrics, including some restructuring professionals. Okay, I think he's talking about the Alvarez and Marshall guys, Michael Prendergast, the interim CEO, and Jeffrey Dwyer. I'm going to guess he's referring to them. A copy of their complaint is attached. In response, the debtors, JOANN Fabrics, which is in a bankruptcy case in Delaware, is seeking to enjoin the lawsuit, arguing that it violates the automatic stay and the order approving the sale of their assets. Notwithstanding the common practice for debtors and their representatives to deceive vendors by encouraging them to ship goods prior to bankruptcy cases and leave vendors unpaid, the Delaware Bankruptcy Court will likely enjoin the Ohio suit. I think he means like rolling it into the bankruptcy case. The Sarachek law firm, which represents vendors in these types of situations, has seen the level of anger that creditors feel when not only companies and their restructuring professionals lie to them about getting paid. We are always looking at ways to do something about it. Maybe this will be a new trend. And then Gordon responded and he said, Joe, thank you for sharing this. I represent the plaintiffs in this suit. I'm fighting a multi-front war with the debtors in the bankruptcy court and with the defendants who are trying to move the case from Ohio State Court to Delaware. You should read my objection to the automatic stay 105A motion that I filed on June 30th, 2025. This is about an end run around Purdue to deliver non-consensual third-party releases of direct causes of action to JOANN's officers and employees. This issue and the broader case are super important for all trade creditors, especially as they experience unscrupulous employees of distressed companies. So he is really accusing the former JOANN executives of trying to use bankruptcy law to protect them from being liable on an individual level of the Ohio plaintiffs' claims of fraudulent misrepresentation and was it like fraudulent misrepresentation and negligence. So I found this pretty interesting, and I'm going to be keeping an eye on what happens with this lawsuit, and also I'm going to try to see if I can find more about this Gordon Novod guy, because I found him pretty fascinating. And the other thing that was like, this was really the bulk of the hearing, was there's still a lot of squabbles over assigning JOANN store leases to other businesses. I believe there's at least one Spirit Halloween store that's going to be taking over more JOANN store. There's also a Dollar Tree, I believe Ross Dress for Less, Burlington. So a lot of these other very common chain retailers are trying to take over the JOANN leases. And a lot of these landlords, some of them are coming forward and saying, hey, this is not cool to assign the leases to these other businesses. We have use restrictions. And there's apparently, it seems like a lot of them, some of them had use restrictions around having discount retailers in their shopping center for various reasons. And there are some disputes about that. Now, there's going to be, I believe, Judge Goldblatt out of this court case, who's overseeing it in Delaware, he is going to have them back to present more. I guess they're going to have an evidentiary hearing to look at more of these facts and to see whether, whether or not these other stores can move into the JOANN leases. I can sort of see both sides, because obviously JOANN wants to find other retailers to take over their leases so that they're not on the hook for that. But at the same point in time, I can also see the side of the landlord who would want to have some say and control over who is actually in their spaces. So that's going to be kind of interesting as well. So there are some other stores that are going to be moving into the JOANN spaces. Okay, now we're going to get to the second bankruptcy case, and that is the IG Design Group Americas. That's taking place in Texas. I believe the judge's name is Christopher Lopez. And this hearing was fairly short, but I did get some information that you'll probably find, kind of interesting. So we have a timeline, and we kind of know a little bit more about what's going on with all of the companies. I believe they have over 70 brands under the Design Group Americas umbrella. Now, Design Group Americas was spun off from IG Design Group, which is based out of the UK. I guess they didn't want to deal with the American branch anymore. So they basically sold it to a liquidation company. It was a Hilco Capital. And so DJ at this hearing said they are going to be, we already know this, but they're going to be liquidating the ribbon business, which they did have a few different manufacturing facilities in the United States. Those are all closing. But there is some light at the end of the tunnel here. I know a lot of us are kind of freaking out because Design Group Americas also includes all of the big four sewing pattern brands like McCall's, Butterick, Vogue, Nomi, Quick Sew. So everyone's kind of worried about the paper sewing pattern business. But here is sort of the positive news is it appears they have some interested parties that want to buy the other sectors. So DJ is going to be totally getting out of and liquidating the ribbon business, but they said the other categories they're looking to sell as going concerns, meaning that these are going to continue to be operational businesses, and that includes sewing, gifts, stationery, and play. So all of those other brands, they're looking to sell to other entities to continue running as businesses and not, it looks like as long as they can find a buyer, they're not planning to shut those down. So those will all continue to operate. And as long as they can find the right buyers for all of these brands, they should still be sticking around. So they are going to be holding sale auctions for the other business segments. And here's sort of the timeline. They're hoping to have a bid deadline of September 8th, hold the sale auctions on September 11th, and have a sale hearing back in bankruptcy court on September 17th. So by September, we should know more about what's going on with all of these brands, including all of these sewing patterns brands. I know there's also some brands that do like crochet stuff, and I guess now the ribbon stuff is gone, but I guess on the positive side, it looks like the other businesses, they it looks like they're trying to make those work as long as they can find buyers. So they do have at least, they said they had 58 NDAs, meaning non-disclosure agreements. So that does look like they have 58 interested parties in some of these brands. In the other segments, there's going to be another, and they are hoping to have some stalking horse bidders, stalking horse agreements in as soon as a few weeks from now. So that means that they would have some interested parties that want to buy some of these companies, which I imagine would probably include all of the sewing pattern brands. I mean, they have the manufacturing facility. There's still, a lot of people are still buying these sewing patterns, so I don't see why I don't know who the buyer would be, but it does look like they have a lot of interest in these brands from sewing, gifts, stationery, and play. So that's sort of a positive out of bankruptcy court in Texas. I'll probably do more of a deep dive on what's going on with Design Group Americas, and I'll probably do some more coverage on the Ohio lawsuit, especially if I can get some more information about what Gordon Novot is doing, because I think that's pretty fascinating. But let me know what you think down below in the comments. Also, if you are kind of new here, we do have some community guidelines that I do ask you to follow if you are going to leave a comment, and subscribe to Sewing Report Live if you want to stay updated on everything that's going on in the world of sewing and crafts. I'm Jen with Sewing Report Live, and I'll see you again in the next one.